And I am the Outreach Committee Chair of the Houston Chinese Alliance. Welcome and thank you for coming to this morning's presentation on a very important lawsuit, very important issue that is going to touch upon all of us, especially our children. George Orwell, in his famous novel Animal Farm, has famously said, all animals are equal, but some animals are more equal than others. Well, if some are more equal than others, then the others must be less equal. In the admissions of the American elite universities, it is no secret that we Asians belong to the less equal. It is not unheard of. Actually, you often hear that a high school graduate of Chinese or Japanese or Korean descent has to have a long list of extracurricular activities on his resume and has to score hundreds of points higher to compete with an applicant of a different skin color. Actually, the inequality in college admissions is not a new issue. For the past 4 decades, the Supreme Court has heard several cases, from Bucky to the recent case of Fisher versus the University of Texas. But in all these cases, this issue is not solved, because in every case, the Supreme Court has affirmed the use of race as a factor in college admissions. Especially, the Supreme Court commended the practice by Harvard University, the so-called Harvard Plan, as the legitimate use of race as a factor in the promotion of campus diversity. Is it? Now, recently, 2 lawsuits have been filed in federal courts, and for the first time, by Asian plaintiffs, which may change the landscape entirely. Because one of these 2 cases is a case against Harvard University, against the very Harvard Plan commended by the Supreme Court. And the plaintiff, in this case, piercing the veil of the so-called diversity, alleges that the practice by Harvard University is nothing but a mechanism to hide its racial and ethnic discrimination against certain disfavored classes of applicants. And the plaintiff urges that the court rule that race cannot be considered at all in admissions, not as a factor, not even for diversity. Now, if the plaintiff prevails in this case, the impact would be far-reaching, so far-reaching I cannot even fathom it today. And the driving force behind these 2 cases, as well as the driving force behind the recent case of Fisher, is just one man. And this man's name is Edward Blum. Mr. Blum is a legend. He used to be a very successful stockbroker and a 40-year Houstonian. He lived here for 40 years. And actually, I still want to claim him a Houstonian, if I may. And he is a Lone Ranger. He is the only soldier and the only commander-in-chief on his long march in his crusade. And he gathered all resources he can in a cause of litigating the vital issues of our time all the way to the Supreme Court. He himself identifies the issues, finds the plaintiffs, finds the lawyers, and finds the funding, and fights all these cases one by one. And the outcomes of these legal battles will affect the direction in which this country goes, as well as the environment in which we live. And I want to bring to your attention that Mr. Blum is not a lawyer. But no lawyer has accomplished what he has. And as you can see, neither is he Asian. But no Asian American has attended to a critical Asian American issue as significantly as he did. Now, without further ado, allow me to have the honor to present Mr. Edward Blum.
Thank you. That was a wonderful introduction. Challenge the use of race and ethnicity in various endeavors, whether it's higher education or employment or contracting. And one of my best allies is right here in the room, Ed Chen and his wife Eugenia Chen. When I filed my first lawsuit in 1993, I had just lost an election running to represent the 18th Congressional District of Texas. I was the Republican nominee, and I was defeated. I didn't win. Most people didn't think I would win, but I was upset with the way that the district here in Texas was drawn. It was drawn along the lines of a racial gerrymander. And what that really meant was that neighborhoods in Houston that were multiracial and multi-ethnic were split apart by their race and ethnicity to create safe, homogeneous racial districts. So in Spring Branch, one side of the street might be mostly African American. They were put into one district. The other side of the street was mostly Hispanic. They were put into another district. And these districts ran dozens of miles in different directions. So these neighborhoods were split apart just because the residents were different races. Well, Ed Chen and I and a few others filed a lawsuit challenging that. And Ed was there at the very beginning. That lawsuit was the first lawsuit I had ever filed in my life. I think probably the first lawsuit Ed had ever filed in his life. And we challenged the state of Texas. And that lawsuit was actually heard by the U.S. Supreme Court. That was our first Supreme Court lawsuit. And we won. David, thank you for saying I'm a kind of a lone ranger, but I've had a lot of wonderful supporters and help along the way. And Houston, Ed and Eugenia Chen marked that. So let me talk a little bit about the state of the law. David gave a very good overview of the use of race and ethnicity as the courts have looked at it over the last, now since 1978. So I want to talk about 3 lawsuits that have been filed that in one way or another challenged the use of racial classifications and preferences in higher admissions. The first case was filed by a man named Alan Bakke, B-A-K-K-E, who applied to the University of California at Davis Medical School and was rejected. He filed a lawsuit challenging what was then a hard racial quota at the University of California at Davis. That is, California at Davis admitted 100 medical students a year, and of those 100, 16 slots, not 15, not 19, 16 slots were set aside for African Americans. He challenged that. That case was heard by the U.S. Supreme Court, and the U.S. Supreme Court ruled in Alan Bakke's favor. They ruled that hard quotas like that are unconstitutional. But, as David pointed out, they did not rule against the use of race and ethnicity in general. They said colleges and universities can continue classifying their applicants by race. You have to check a little box. You're Asian, you check this box. You're white, you check this box. They can still do that, and they can still raise the bar for some and lower the bar for others. That's still okay in the pursuit of this goal called diversity. But what they couldn't do is have a hard quota. That was the first major lawsuit. The next lawsuit came in 2003 when 2 white applicants one challenged the University of Michigan's undergraduate program, and the other challenged the University of Michigan's law school program. In those cases, the plaintiffs brought a facial challenge to the use of race and ethnicity. That is, they didn't argue that well, there's quotas here and we need to end the quotas. They argued, well, there are quotas, but we need to end the use of classifications and preferences, period. Well, the court didn't see it that way. The court found that the University of Michigan undergraduate program was a quota, and they struck that down as a quota, but they didn't strike down as a quota of the University of Michigan's law school admissions policies, and they also sort of strengthened, to a modest degree, the latitude that universities have in raising the bar for some and lowering it for others. So that was a setback for those of us who believe that your race and ethnicity should not be a factor, either to help you gain admission to a university or a job, or to harm you in those settings. One of the interesting things that came out of that case was the Supreme Court said, look, before a university is allowed to raise the bar or lower the bar, if they must attempt to try something race neutral to achieve this diversity. So, what that meant, at least for the University of Texas lawsuit, which was the one that came right after the University of Michigan was, the University of Texas has, as all of you probably know, something called a top 10% admissions policy. That top 10% admissions policy was passed by the legislature in 1997, signed into law by then Governor Bush, and that required every college, every public college in the state of Texas to admit any student who graduated in the top 10% of his or her graduating high school class. Now, prior to this law, the University of Texas was using race-based affirmative action. That is, the University of Texas was classifying people and treating them differently. Well, that was struck down in 1997 by a local Texas court. So Texas in 1997 had to abandon the use of race and ethnicity, and instead they implemented this race-neutral top 10% plan. So what happened to the University of Texas student body in 1998 and 1999 and 2000? Well, to no one's surprise, at least not to my surprise, the number of African Americans, so now those kids had a shot at going to the University of Texas, and because Asians seem to be graduating in the top tranches of public high schools throughout the state of Texas, Asians now, their population started to expand at the University of Texas. So as it turned out, it was unnecessary for the University of Texas to use affirmative action when they had this top 10% plan in place. Well, the day that the University of Michigan cases came down in 2003, the University of Texas said, wait a minute, we're now allowed to reintroduce race into the equation. Now the Supreme Court has said colleges and universities unequivocally can use race. We, the University of Texas, who have not been using race, but instead have been using this top 10% plan, while we are going to still continue using the top 10% plan, now we're going to add race-based affirmative action on top of it. The day that opinion came down is the day that the University of Texas announced what they were going to do. And that was the day that I and others decided that the University of Texas was about to undertake something that was unconstitutional. And that is reintroducing race on top of something that was already effective. So in 2008, Abigail Fisher, who attended a high school out in Sugar Land, applied to the University of Texas. She was in the 11th percentile of her graduating class, so she didn't quite make it to the top 10. So she had to apply, and because of that, we argue that her race was used against her in the admissions process. We sued. The University of Texas had applied the wrong standard when it reintroduced race, that they needed to go back and apply the new standard that the Supreme Court had articulated in the Fisher case. And if they could overcome that new standard, then the University of Texas could use the right case to end the use of race and ethnicity in higher education. When we filed that case, we didn't ask the court to do it because we felt that it would take a couple of cases to develop our theories and find the right set of facts to do it. But if we win again at the Supreme Court, we think the hurdle that they articulated the first time in 2013, that hurdle will be raised, it will be more fully fleshed out, and at least for the next 2 or 3 years, while the Harvard lawsuit is being pursued and the UNC lawsuit is being pursued, it will be harder for universities to use race and ethnicity, not impossible. Now, how do we go about making it impossible for universities? Oh, thank you. How do we make it impossible for universities to use race and ethnicity? And that's where the Harvard lawsuit and the UNC lawsuits come in. So here's what I did. I decided right after the Fisher case was decided in 2013 that the next step in this process that began with Alan Bakke applying to medical school back in 1978 would be to challenge outright, to ask the court to end the use of race, period, in the admissions process. And what that means is that when David Cow's children apply to Duke or to Stanford or to Yale, on the application, there is no box that should be checked to determine whether you're Asian, whether you're Japanese, whether you're Pakistani, whether you're Indian, whether you're white, black, Hispanic. All those boxes will go away. And rather than have names like Sam Cow or Ed Chen or I don't know, Milton Rabinowitz or Sammy Garcia, all the names are redacted so that people reviewing those applications won't say, aha, here's an Asian, we have too many of those already. Or here's a Hispanic, God, we really need more of those, let's admit him. So that's the goal of these lawsuits, is to eliminate the consideration of race or ethnicity in applying. So I needed plaintiffs. I needed Asian plaintiffs. And finding plaintiffs to challenge the Ivy League admissions policies, Harvard in particular, is not an easy thing to do. So I started, designed 3 websites: harvardnotfair.org, UNC, University of North Carolina, notfair.org, and UW-notfair.org, University of Wisconsin. And I launched these 3 websites, and I put out a press release, and I had some friends help out with doing press events in Madison, Wisconsin, Boston, Massachusetts, and Charlotte, North Carolina. And lo and behold, we had some press coverage. It was very helpful. Some of the press coverage wasn't very commendatory. The reporters didn't really like what we were doing, and you could tell that from the stories that they wrote and the editorials that appeared in newspapers. But it did the trick, and we ended up with, through those websites, with at Harvard specifically, about 300 students who had either recently been denied admission to Harvard or who had been denied admission to Harvard in the past telling us their story. And their story was absolutely remarkable. These kids were valedictorians. They are either immigrants to this country or first generation from China, Vietnam, India, Korea. They had outstanding test scores, outstanding AP exposure and AP course grades. They won science exams, they won debates, they won tennis tournaments, they played golf. They did everything that you would want kids to do when they're competing at the most competitive schools in the country. So those websites led me to, frankly, just one individual, one Chinese young man from California. His father contacted me and said, we're interested in pursuing this. I got on a plane, I flew out to California, I met with the family, I met to make sure that they understood what they were getting into, and they agreed, and lo and behold, the websites were launched in April. On November the 17th, 2014, we filed a lawsuit against Harvard, and we filed a lawsuit against the University of North Carolina. I have yet to file a lawsuit against the University of Wisconsin because I haven't found anyone willing to sort of be the plaintiff. Now let me stop and tell you about the structure of the Harvard lawsuit, because it's important that you understand what we've done differently with Harvard that we did with when Ed and I sued the state of Texas and when Abigail Fisher sued the University of Texas. What we did was no one today knows the name of the young man who has filed this lawsuit. We formed an organization, and that's the handout that you have. We formed an organization called Students for Fair Admissions, and it is a not-for-profit 501c3 organization that has now been recognized by the Internal Revenue Service as being a legitimate not-for-profit public interest charity. We have members. Students for Fair Admissions now has a little over 300 members. And I encourage all of you to join it. Go to the website and you can join it. All that it requires is your name, your email address, and I think that's it. You can become a member. Or if you have been denied admission, if you're a 17, 18, or 19-year-old who has been denied admission to a college or university, you can do more than join. You can not only join, but you can tell us about yourself. So, of the 300, I would say we probably have about 100 students throughout the country who have told us their names, their SAT scores, what year they applied to college, the colleges that rejected them, something a little bit about their extracurricular activities. So, of the 100, I have reached out to, I'd say, about a dozen additional Asians and contacted them and said the following. Look, a student who said, I'm willing to have my name revealed, understood that there'll be no depositions. You won't have to testify in court. It's going to be long and arduous. We are in a phase now called discovery. And what this means is that over the next year or so, we have asked Harvard and the University of North Carolina for their admission data. Harvard used to provide this admission data just as a matter of course. Harvard will every year announce the percentages of Asians and African Americans and whites and Hispanics that it admits, but in 2003, Harvard stopped providing data showing the number of applicants by race and ethnicity to Harvard. Now that's an interesting coincidence. For dozens of years, you could look at Harvard's admissions pool and say, oh, of the 35,000 students that applied to Harvard, 4,200 were African American. 2,800 were Hispanic, and this percentage white, and this percentage Asian. Well, just a few weeks after the University of Michigan cases were decided, Harvard ended that practice. Now, why did they do that? Whereas the University of Texas and most public institutions continue to make that information available, they have to, often by state statute and by FOIA request. But Harvard and many of the other Ivy Leagues have stopped doing that. And why have they stopped doing that? And all of this is going to come out in the discovery process, is because we believe that at Harvard specifically, of the 35,000 students that applied, somewhere around 18,000, give or take, are Asian. That means that a significant percentage of Harvard applicants are Asian. Our initial studies that have been done by scholars widely respected also suggest that of the students applying to Harvard who score 20 are Asian, and of the students that score 2,300 or higher on their SATs, 55% are Asian. So it's our belief that Harvard and Yale and Princeton and the other Ivy Leagues simply won't take applicants who score much below 2,000 on their combined SATs. That's about the cutoff, regardless of your race. So it seems that if Asians were in the lower tranches of SAT performance, then it would be no surprise that maybe their numbers were static. But our data suggests that that's not the case at all. And what we have are a couple of control groups that we point to in our complaint that will additionally come out in this discovery process that we believe will prove that Harvard has an unfair and unconstitutional quota against Asians. And that is what is happening at schools like Berkeley specifically and Caltech specifically. So, in 1992, Harvard admitted 19% of its freshman class were Asian. In 2011 and 2012, about 17% of its admitted class were Asian. Now, what has happened to the Asian population during this period of time? We estimate that the number of Asian applicants to these schools has better than doubled, but not quite tripled. We don't know where that number is. Because of the growth in America's Asian population, we can track this. So what has happened at schools that don't use race and ethnicity as a factor? Well, we have two schools that I just mentioned, Caltech and Berkeley. Well, Asian in 1990 go up significantly. Same story at Berkeley. 1992, I think it was about 16 or 17% Asian. They were forbidden to use race beginning in 1996. Now, Asian population at Berkeley, I think last year, was also over 40%. So schools that don't use race have seen this increase, yet Harvard, year after year after year after year, is the same. 17, 18, 16, 19, 17, 16. Now, that kind of flatlining in light of the growing number of highly qualified Asian applicants suggests a quota. And remember, back in 1978 in Bakke, quotas are unfair and unconstitutional. Same thing in Michigan, quotas unfair and unconstitutional. So we've approached the Harvard lawsuit on two fronts. We've said, number one, Harvard has a quota. They're denying it's a quota, but for all intents and purposes, it's a quota. And then secondly, we're asking the justices, look, in 78, you said it was okay, but there had to be certain parameters before it was okay. In 2003, you said quotas are not okay, but race could be okay. 2008, you kind of danced around it, but the time has come when America is so multiracial and multi-ethnic that it is no longer a question of whites versus blacks, which is what the affirmative action policies were originally designed to address. Now we have a multiracial, multi-ethnic society in which Asians are being penalized. There's a bamboo ceiling against Asians in America's most competitive universities, and who is benefiting from these quotas against Asians? African Americans are benefiting, Hispanics are benefiting, and whites are benefiting. Whites are overrepresented at the Ivy League based upon the data that we have gathered, what we know to be admissions trends. So we're going to go to the court and say, this is not about whites and blacks. This is now, you're pitting a multiracial America against one another. And hopefully we'll succeed at that. Discovery will last about a year. There will then be a series of perhaps a trial or motions for summary judgment. The court will consider it. We think in about 2 years, a year and a half to 2 years from now, we will have our opinion from the local court in Boston. That's win or lose. Everyone recognizes that the next step is the Court of Appeals, and then after that, the Supreme Court. So just like it took about 4 years for Abby Fisher's case to be heard, almost 5, now we're going on 7 years by the time the Supreme Court has sent it back, and now we're going back up again. It could be a very long slog. So I'll stop here. I encourage all of you to please join Students for Fair Admissions. Pass the word about it. Any financial help that you can render in this would be greatly appreciated. I think there's some note about how to go about doing that on the handout. We have lawyers who estimate that it will cost about $1 million a year. David and I were talking about this, about $1 million a year to pursue the Harvard lawsuit, a little less for the University of North Carolina. I've raised money that takes us through about the first year. I'm hopeful that we'll have money for them the second year and the third year and the fourth year, but whatever you can do to help would be greatly appreciated. But joining and passing the word about students who have been rejected and participating in this is very important. We need new students every year, because at some point our old students that joined last year will no longer, although they'll be members, the court won't recognize them as harmed members. So we need new Asian students joining all the time. So thank you, and I'll take questions from that. Over the years, a number of people have contacted me and have wanted to file lawsuits challenging various admissions policies or employment policies, contracting policies. They were afraid of retribution. Frankly, I have had my name on lawsuits, and Ed Chen has had his name on lawsuits, and nothing has ever happened in terms of retribution. Ed was a faculty member at the University of Houston. His university never came after him. There may have been some grumbling, perhaps, but but there's been, but parents were concerned that their 17 or 18-year-old son or daughter going off to Rice instead of Harvard would be penalized, that faculty members and fellow students would not agree with challenging these kinds of policies. So over the years, it's been difficult to find people who would stand up and put their name on a lawsuit. So our options were limited because we knew we wanted a large group of students to participate. So forming this organization and having them join was a way that their parents felt more comfortable that, all right, look, my son applied to Harvard, he's at Stanford, that's a good outcome, but one day he might want to apply to medical school. And lo and behold, if he's known as the man who killed affirmative action, applying to medical school, maybe that will harm him. So that was the rationale behind that. Yes, sir?
I have two questions. The first question is, do we still consider the Asian Americans minority group, or is part of the majority? Because affirmative action is for protecting the minorities because of the social economic status. So do we today consider Asian community, part of the majority group? That's the first question. Now, second question, if we believe that the beneficiaries of the Asian discrimination are the white Americans, the Hispanic Americans, African Americans, how do we make that determination? If we find that it is really the African American communities or the Hispanic students are really the beneficiary, how do we win the support to our lawsuit?
Okay, two good questions. The first is sort of a legal policy question. The second, I think, addresses some kind of social issues and policy issues. Let me attack, or not attack, but let me address the first question. Are Asians a minority? Well, I think they are recognized as a separate ethnic group and race for the purposes of various public policy arenas. There are four that come up. Contracting, if there is a small Asian-owned business person in this group, and the city of Houston wants to build a new swimming pool at a community center and puts that bid out for consideration, Asians are considered as a minority group in that arena. Employment, voting, and university admissions, pretty much the same thing. So for the most part, some Asians, don't ask me the rationale behind it. For instance, Pakistanis are considered a racial minority group that would benefit from these kinds of affirmative action policies, but Afghans are not. Don't ask me how that came about, but as Ed Chen will tell you, we learned a lot litigating various cases over the years. So the answer is yes, Asians are still considered a minority. Now, I think perhaps the press and certain advocates on both sides of the issue will sort of lump together whites and Asians in kind of one pile and consider blacks and Hispanics in another pile. You brought up the issue of socioeconomic issues. This is a very important point, and I'm glad you brought that up. Often I am asked, well, if you win and Harvard has to open up its admissions process in a colorblind way, that is, they cannot consider whether Mr. Patel is Indian, or Mr. Chow is Asian, or Mr. Rabinowitz is Jewish, or Mr. Garcia. If they do it in a race blind way, then all that you're going to have are a bunch of Asians, you know, at Harvard. What do you think about that? Is that a good thing? And my answer is, you know, I frankly don't care. And then the follow-up answer is, if you're concerned that we have institutions throughout this country that will be, for the most part, majority Asian, and then white, and very few Hispanics, and very few African Americans, then there's a way that we can go about creating diverse environments without raising the bar or lowering the bar for people based upon their race. And that is, if Harvard said, all right, we're no longer allowed to use race, but you know, we want to have 15% of our incoming class from disadvantaged backgrounds, where maybe mom and dad earned less than $40,000 a year, or we wanted to make sure that we had kids who kind of grew up in tough neighborhoods or went to lousy high schools, but proved to be, you know, academically competitive, even though they went to a lousy high school in a lousy neighborhood. And we're going to lower the bar for those kids a little bit. That's fine. I think that's a great idea. And that perhaps, we think, will help admit a sufficient number of African Americans, Hispanics, and kids, Asian kids, whose, you know, dad is a shrimper down in Angleton, who's first generation Vietnamese, who attends a lousy high school, but he happened to be the class valedictorian. Maybe he's not as competitive as a Vietnamese kid who went to straight Jesuit or Kincaid or St. John's or something. But maybe that bar is lowered a little bit for him as well. So that was part of your first question. Now your second question is, how do we convince people of this? Well, I don't think we need to do much of that. We're going to do some. We have to continue doing that. But polling data suggests that America has really moved to our side. That during the Fisher litigation, when Fisher was at the Supreme Court, the Gallup poll and other polling organizations did numerous polls in 2012, 2013, and then some in 2014. But the year that Abby's case was at the Supreme Court and was about to be decided, the Gallup poll did a number of polls, and they asked the following question, because you can really affect the outcome of a poll by the way you ask a question. They asked Americans, do you think a student's race should be considered when they apply to college? Pretty simple question. Not, do you think a student's race should be considered in order to overcome, you know, years of slavery, or in order to create a harmonious, racial, diverse environment? Just, do you think your kid's race should be used? Period. It's a pretty simple question. 55% of Americans, 65% of Americans answered that question as no. And African Americans split just about evenly on that question. Just about evenly. I think it was 48 to 52 said, no, your race shouldn't be a factor. So I think as long as we continue finding plaintiffs, we continue to articulate these issues in a way that America understands. Look, everybody's got you know, a son, a daughter, a grandson, a nephew, a niece that will be applying to college. And everybody pretty much wants a fair shake for those kids. And most of America realizes now that admissions is a zero-sum game. If you lower the bar for some, you're raising it for others. And that's just unfair, and it's just un-American. So I think we're moving in the right direction there. That's a long answer. You guys must be sick of this. Yes, sir.
Mr. Blum, I think Professor Lee took the question beyond the college admission. Before the lecture, we talked about our mutual friend, SB Wu.
I'm going to back up just a little bit and talk about SB Wu, these groups. I mentioned to you I've been to Nassau County in New York on Long Island, and then Livingston, New Jersey. And a couple of people have brought this up to me, and I'll be the first to admit that I don't know of the tension and the internal debate within 80/20 and SB Woo. I think each public policy arena has unique features to it. And employment is one of the most complex and complicated areas in which race becomes an issue. And my response to your question is nuanced, and I'm going to just give you an example of this. While it is ideal for employers, public employers and private employers, to be forbidden to use race or ethnicity in the hiring process or the promotion process, there are instances in which that becomes something that probably should be done. And I'm just going to give you one example. City of Houston, which is a public as opposed to private, the City of Houston has a police department. That police department has to police a very multiracial, multi-ethnic city. There are requirements within law enforcement that would dictate that a certain number of Hispanic police officers are hired. Just because, number one, they have language skills, number two, they look Hispanic, and three, they can go undercover. So if there are Hispanic gangs operating in Houston, it's going to be pretty difficult to send, David Cow as a police officer or Edward Blum as a police officer into that kind of a situation. That's one example. The second example, let's see. I'm Jewish. Let's say I own a company that provides kosher food products in New York City to kosher grocery stores and supermarkets. And I need salespersons to call on these various kosher shops. And I run an ad, and I get 2 applicants, one black, one white who's Jewish who keeps kosher. Now, do I have the right to tell the black that, well, I'm going to not hire you because you're black? I need a white Jewish kosher employee to call on these white kosher butchers. And I can kind of flip it around a little bit. Suppose I'm African American and I have a African American beauty products company, and I need salespersons to take my products around to African American beauty shops and barber shops and things like that. And 2 applicants show up, one's Chinese and the other one's black. Do I have the right at that point to tell the Chinese, hey David, I'm not hiring you because you're Chinese, I'm going to hire this black woman because she... So just a couple of examples that I hope clarify that employment law is a little is distinct from some of the other arenas that I hope that answers your question.
First example, one step further. I think we understand, especially in the Southwest Houston, I think we did Asian police officers because of language, culture, and many other issues.
Yeah.
But if we take the question one step further, how about some ethnic representation at the leadership of the police department?
Yeah, that's a great question. And I wrestle with it. I think what the... So I wear 2 hats. I wear an amateur lawyer hat, and then I wear just a sort of an American citizen hat. So let me put on my amateur lawyer cap and answer the question. I think those are intensive fact-finding issues that that courts have examined pretty carefully. The most recent case was a case of firefighters in New Haven, Connecticut. The New Haven firefighters have, if they want to advance up the hierarchy from firefighter to lieutenant to captain, et cetera, they have to take an exam. And the Hispanics and African Americans that took the exam scored much lower on the exam than did the whites, and I don't know if there were any Asians there, but they scored much lower than the white applicants. And the way the civil service in New Haven was structured was the highest achieving scores were then put into a pool that then went on to become considered for lieutenant and what have you. So that was unique because, kind of a firefighter is a firefighter. You're out there putting out, there are no Asian fires or African American fires, there's just fire. So that was kind of unique. Now, if a case came from the New Haven police officers about that same exam that African Americans didn't do as well on as whites, the court might say, well, because there are no ethnic fires, but there are kind of ethnic policing issues, maybe we need to allow for a jurisdiction to take lower scoring applicants and promote them, because there are police issues that. So that's sort of an amateur lawyer in me. The American in me says, well, look, I'd like to eliminate the whole thing, but maybe there are just narrow instances in which affirmative action in employment could be considered.
I think the reason I pose the question is not a hypothetical one. In Houston, that really happened because we're not talking about promotion. Because if we talk about top rank police officer, it's appointed. Okay, basically mayor or the county judge cannot influence that process.
Yeah.
And a few years ago, when we had the Chinese American police vice police chief retire, that position was not going to be filled by a Chinese American. Many of the people in this room went to the city hall. We talked to the city council member, we talked to the mayor, we went to the city council meeting, testified. As a result, we fired. And we got that position filled again by a Chinese American. I think the people in this room can tell you how much difference that makes. When you have the top ranking Chinese American and the top ranking police officer, that makes a difference. We have a person we go to. Now today we have people at both the Houston City Police Department as well as in Harris County Sheriff's Office. It helps a lot.
I can see that, yeah. I guess that the idea of political appointment is, I don't think you can probably bring a suit against the city of Houston for a political appointee, but if there were, the example I gave from New Haven, if something like that existed and Asians were being passed over for lower scoring whites, Hispanics, and African Americans, then a lawsuit could probably be initiated.
I mean, to follow up on this question, now, as you just elaborated, you have to compare apples with apples. Some of the cases are unique. Now, the Fisher case, the Harvard case, is about education, it's not about employment. I mean, this is a common law country. When you apply cases, you have to apply the facts. So what is the nexus between the possible outcome of this case on the other affirmative action cases? What is the nexus? I mean, why do you think people are even worried about that?
That's a great question, and it is, I think Ed Chen and I know from our experience in the sort of the public arena, trying to convince people to vote in elections that end all of this. Education is the most important of those four policy arenas. Contracting, employment, voting in elections and education. And the reason is it speaks to itself. Everybody has been to school. Everybody has competed in some manner. I say everybody, most have competed in some manner in school. We have now the vast majority of kids applying to college, competing to get into college. We understand all of that. We understand what being admitted to Harvard means in the life of our children and grandchildren. So the nexus is that if we win this, if we win the education battle, we've probably won about 75% of the battle in all. That employment, elections, and contracting will evolve in that direction as well. But if we can end this practice with the Harvard and UNC lawsuits, and the court strike down the use of race, we've accomplished pretty much, I think, what we need to accomplish. Ed, you want to talk?
Let me just make some comments about Edward. First of all, he mentioned that he was Jewish. He's also been back to Israel to fight against the war there. And so he is not only a patriot of the United States, but he's also a very good Jew. And we have to remember that he and the United States at the present is turning certainly against Israel and the Jewish people, and we hope that we can get support for Israel from the United States. My question to you, though, and also he did fight the affirmative action at the City Hall that you were talking about. We were on what was it? We had a vote.
Referendum.
We had a referendum. We had a referendum to say that we would end the affirmative action policies of the city of Houston. It didn't win. We thought we were going to win, but at the very last they came in and they actually defeated that particular one. But my question to you is, people have been saying, and he's also a Republican, I'm a Republican, I was the vice chairman of the Harris County Republican Party. People have been saying that the Asian people have been going away from the Republican Party to the Democrat Party. And what can we do as Republicans, you and I, help to convince people that if you do go and vote, I'm not going to say how you should vote, but look at the candidates, see which ones are better for you and for the United States of America, as Ed Blum is doing, because he is really a real patriot. And so how about the question with respect to what can we do to help get more Republican Asians?
Oh, God. That is a great question, and I am not going to answer it.
Well, I will work. I've been continuing to work within the community, and what I would say to you then is go out and participate in whether you want to be a Democrat or Republican. I hope you'll be a Republican, but go out and participate and do something. Don't just stand there. Okay?
If I had any insight into that, Ed, I would have been able to convince my co-religionists to vote Republican.
I know.
And as all of you know, Jews and Asians now give about 75% of their vote to Democrats. So if I had any answers at all, Ed, I would have already put them in motion within my own community. But yeah.
So back to this case, is there any possibility that the Supreme Court is not going to hear this case?
Oh, sure, David. Yeah, absolutely. There are, as you may know, I'll just tell you, about every year, the Supreme Court has somewhere between 7,000 and 8,000 requests for oral argument. That is, there are 7,000 to 8,000 appeals from lower courts that go to the Supreme Court every year. Of those 7,000 to 8,000, the Supreme Court takes about 70 to 80. They used to take more, so it's really about 1% of all cases get taken up by the Supreme Court. Although that's of the 7,000, probably 4,000 are not worthy of consideration. So there are many thousands that are worthy of consideration, and to have 75 out of 2,000 or 3,000 is still a very small number. So The reason we're hopeful that either this case gets taken up or the University of North Carolina case gets taken up, and there's no guarantee which one makes it first. Both of them bring up similar legal issues, identical legal issues, but just with different sets of facts, as you say. So the court seems to pay attention to this issue. The media pays a lot of attention to this issue. Unfortunately or fortunately, the media pays a lot of attention to kind of the cases that I'm bringing. So that can be good on the one hand and bad on the other. But when Harvard starts to reach, you know, a critical point in the appellate process, everybody already knows about Harvard. Every justice on the Supreme Court knows about this lawsuit. Their clerks know about this lawsuit. The articles that they read, the blogs, the legal press, they know all about this. Every twist and turn in this litigation is going to be publicized. So, you know, when it does knock on their door, it won't be for lack of them not really knowing about it, or thinking, oh, this is just, you know, one of the many thousands that we get. It'll be a very high-profile case. And frankly, the Harvard case is the ideal case to bring. It is the ideal case. And I think the justices may recognize that. It wouldn't surprise me if North Carolina goes up first, that they just sit on North Carolina, waiting for Harvard to come. Or they take North Carolina and they reach down into the lower courts and say, hey, this is an identical lawsuit. We know all about this lawsuit. Let's bring both of them up at the same time. They've done that in, you know, in other cases as well.
And the next one is going to be really important to potential donors. What if Harvard says, okay, plaintiff, I'm offering you a seat, okay? You can transfer from UC Berkeley to Harvard. Let us settle.
Oh, yes. That's a great question. It's funny, you'll appreciate this being the real lawyer between the two of us. The court in the First District Court of Appeals has rules, or maybe it's the district court has rules, that before the discovery process begins, the two sides must submit to the court a joint memo in which they discuss their efforts at reaching we
compromise.
had to do this. It's not like, you know, all right, so we said, yes, we'll be willing to drop the lawsuit if you will admit the one student that is mentioned in the complaint and the others that have now joined Students for Fair Admissions, and Harvard drops the use of race and ethnicity completely going forward, and you pay our legal fees. We threw that last one in, and of course they declined. All that.
I don't blame them.
Yeah, so I would have taken out the legal fees and agreed to see if they would agree to the other two points. Yeah, I'm gonna. Yes, ma'am.
So the Harvard case is currently under discovery stage. Does that mean Harvard has to open their admission data to the public?
They have to open it to us,
Okay.
and we're now in the process of telling the court and telling Harvard what we want. And of course, what we have told Harvard what we want is really quite overwhelming to Harvard. Harvard's quite distressed about what we have asked for. We have asked for every admission file going back to 2008. And Harvard said, well, that means that you want 5.9 million pieces of paper. And we said, yes, we want 5.9 million pieces of paper. And they said, that's not going to happen. And we said, well, we'll meet you halfway. Instead of 5.9 million pieces of paper, we'll select 1 million pieces of paper at random. We'll get our expert you get your expert, will go to the database, and will just pick you know, 1 million pieces of paper at random, and we'll settle for that instead of the 5.9 that would cover everyone. So we haven't heard back from Harvard on that yet, but this is the process that we're in. And ultimately, if we want this and Harvard says no way, then the judge will decide how much to turn over. But because this is a civil rights lawsuit, in the past, civil rights lawsuits have been very factually intensive. So we anticipate the court being sympathetic to providing us with more information than Harvard wants to provide.
So can you predict the bottom line? Where will be the bottom line for you?
For me?
How much information you want?
Well, we want it all, but we'll be very satisfied if we get, I guess we'd be happy with maybe 40,000 individual applicant files chosen at random over a 5 or 6 year period. And we want the complete data set, the computer data set. So all that they have to do is provide us with a hard drive with all of their admissions data on it. And then we can look at maybe 40,000 individual students to see how they were treated during the interview process. So, sir.
Yes, Mr. Blum, you've spent 20, 30 years studying these admissions processes, so I wanted to ask you this question. What have you learned regarding the Harvard admissions process with respect to the test scores? And the reason I ask this is, a few weeks ago in the Wall Street Journal, Oklahoma University published a full-page ad where it set forth how many students in the top 10 schools in the United States had National Merit Scholars. So these are the highest scoring students on the standardized test scores. I was surprised to see that Harvard only had 300 approximately out of an entering class of 1,600. So only 300 of the 1,600 Harvard students are in the top scores of the SAT. So something's going on inside of Harvard where they do not assign to the standardized test scores the importance that you seem to assign on your statistics here that you put forth. So something's going on there that doesn't value the standardized test scores as highly as you would appear to value them. So what do you know about the internal process? Why isn't it that 1,600 students at Harvard are National Merit Scholars? That's my question.
It's an excellent question. And I don't know that I've got a sufficient answer for you. I know that the applicant pool, I'm going to take you just a little bit into the legal weeds on this, and David, come bail me out if I'm stepping water. What we're attempting to show the court is something that the government attempts to prove in an antitrust case. So, let me give an example. Coke and Pepsi seem to have the same price at the grocery store day after day, week after week. Coke goes up a dime, Pepsi goes up a dime. Coke goes down a dime, Pepsi goes down a dime. Whereas root beer and ginger ale, one goes up $1, the other one goes down 50 cents. The other one goes up 50 cents, the other one goes down 50 cents. The fact that Coke and Pepsi seem to move in tandem, whereas Dr. Pepper, root beer, and other soft drinks fly around in price, suggests in an antitrust case that there is collusion between Coke and Pepsi. And that's sufficient for the government to bring an antitrust case and to get into Coke and Pepsi's private files. So, going back to the SAT scores and the national merits, we recognize that that of the 1,600 students applying to Harvard, of the 35,000 that apply to Harvard, Harvard could tease out every kid who scored 2,400 on the SAT and was a National Merit Scholar, just those people, put their names in a hopper, pull out 1,600 of them, and there'd still be quite a few thousand left over. So we're not arguing to the courts that that's what Harvard needs to do. What we're arguing to the courts is that of those names in the hopper that Harvard puts in with the 2,400, the perfect 4.0 GPA and all of that, they are reaching in and pulling out a name, and it's Sam Chin, and they're looking at their tally sheet and saying, no, we have enough. They're pulling out a name, Sam Garcia, saying, okay, that's a good one. Sam Washington, yeah, that's a good one. Sam Anderson or O'Malley, yeah, that's a good one too. So it doesn't surprise me that much that Harvard, doesn't have an entire class filled with National Merit Scholars. But I know one thing that I'm positive of, and that is if we're successful, they're going to have a lot more. Because there will be, instead of 17% of incoming freshmen being Asian, it'll probably jump up like Caltech did. And those kids are going to be National Merit finalists and scholars. So, does that answer your question?
Sort of. I mean, I think the whole process is fairly mysterious.
It is. It is mysterious. And Harvard makes it mysterious. And it's going to be an enormous burden to overcome that mysteriousness. What we're hopeful to find during this discovery process is that there are, hundreds of people that we hope to interview. And somebody's going to say, a few will say, hey, the admissions committee asked me to interview kids in the LA area, and I went out and I interviewed 15, and they told me of the 15, give us your 5 best, and I sent the names in, and I got an email or I got a call, probably a call, from somebody saying, gee, of these 15 names, 4 are Asian. Can't you do any better than that? So we suspect that we're going to find people that are going to come forward and tell us those experiences. Yes?
When you talk about fair admission, are you only taking out race as a factor? Because I'm thinking in my head there's disability as part of the factor, sexual orientation, gender. Someone is always going to feel that they're at the smaller percentage. So if we take race out of the factor, we'll have more. So when or if Caucasian students become a smaller percentage, are they going to fight again? Because in my head, I'm just thinking this is never going to end because there's always going to be somebody, a group that's at a smaller percentage.
Well, let's hope you're wrong, but that's a common concern. Race in America is very unique. Legally, race is a world unto itself. If Harvard said, you know what, the admissions committee sat down and we decided that we're going to admit only people taller than men, no, that's a bad example. We're only going to admit people that are really swell dancers. We just want great dancers here at Harvard. The hell with anything else. It's stupid. It's foolish, but they can do that. The law, when it pertains to race, is very unique. So if Harvard said, well, hey, we want more disabled people, or we want some additional gays, or we want some additional heterosexual, as long as race isn't part of that equation, that's something that, that they can pursue.
In other words, it is only the racial policy in how racial actual attack, not anything else.
It's just that. Eugenia?
I just have some experience to share with you. We have 2 children, okay? The girl is 6 years older than the boy. When she was just the 2nd year in high school, she came to us. She said that she was going to college. I said, where? She said, Rice. I said, you got admitted? She said, yes. And she had one SAT, but not the second one. So she wasn't a National Merit Scholar. She had good grades, so she went to Rice with full scholarship. Okay, but she was an electrical engineering major. That went fine. When my son graduated, both of them went to Bel Air High School. He was National Merit Scholar. He was the top 3% of his class. He got rejected from Rice. And I thought, well, he didn't do any worse than his sister. So I got to talk to one of the members of the admission, she said, there are 3 things wrong with your son's admission. I said, okay, tell me. She said, okay, number 1 thing was he went to Bel Air High School. At the time, Bel Air High School was the best high school in Houston. And he said, there are 30, 40, 50 of the National Merit Scholar from Bel Air High School. He's just one of them. I said, that's correct. And number 2, he said he's not the top 1%. He's about the 3%. I said, that's correct. So he said, another thing is he applied for biology. At Rice, there was no pre-med. Biology is pre-med. That's very difficult. He said, one more thing. I said, what's the one more thing? He said, we want diversity. I said, okay. What's that diversity? You mean race? He said, actually, no. I said, well, then what? He said, we go by how your name starts. See? I said, so if your name is Johnson or Jones, that would be the most. I told my son, I said, well, you had good grades and everything. I said, he said, well, I have a place to go anyway because he could go to UT or A&M with no problem. But that thing kind of amazed me a little.
It's an amazing story. Thanks for sharing that with us, sir.
Just 2 comments. We have been into enough of that admission or school admission meetings, and they always say, we are looking for the whole package of a student. So that means if you are like short put, national number 2, you don't need a 2400 SAT. You can get into Harvard, okay? Or you have started up 2 companies when you're high school. Then you don't need a 2400 SAT. Okay, so getting to that means their admission process is a complete different perspective rather than we Asian always think 2400 SAT, that's all you need to get to Harvard. It's not the case, first. And second, last name is very tricky, especially in America. We have seen enough Chinese last name, but their look is totally Caucasian. Okay, with LIU, last name, we think it's Chinese, but when you look at the real person, it's a Caucasian. Because in America, there are so many interracial marriage. You know what? Al Gore's daughter married to a Chinese. So now Al Gore's grandkids is a last name Lee. So he belongs to half Chinese or half Al Gore. So ethnic group is very tricky because once they get interracial marriage, then become dropped down to half and half. You classify them in Chinese, Asian, or Caucasian. That's why in NIH, in biomedical research, now they drop ethnic Because if you need to look at it, you need to check every single base in your DNA. See whether you are really Chinese, Asian, or what, or mixed, you know? So if we are getting to that, I'm trying to point out in front of you, Mr. Blum, if you really need to know what Harvard's admission process is, get all their data. And you can have a complete picture, even though it's a 5 million documents. Otherwise, they will say, well, we only have 10% of our data. And you cannot draw a conclusion by the small statistics. Or you only randomly take 1 million document or 40,000 people. This is not a majority of the case. Their admission process were more complicated.
So I'm going to give one more anecdote and then take another couple of questions. Mysteries of university admissions, especially places like Harvard and Rice and America's most competitive universities. We have a laboratory for how this really began and how it's and how it played out over the years. And the laboratory began in the 1920s at Harvard. And we spend a lot of time on our complaint against Harvard about this, and that is because of America's immigration policies in the late 1800s. By the early 1920s, a number of Eastern European Jews had moved to the United States, and because of a variety of reasons, most attribute that to sort of the culture, the family culture, and the emphasis on academic achievements. More and more Jews were applying to Harvard, and at that time, Harvard admitted strictly on a meritocracy. You had to take an exam, you had to get a couple of, recommendations, but it was basically, you scored 2,400 on the SAT, you're applying, or that version of the SAT back in the 1920s, you're at Harvard. And by 1924, almost 30% of Harvard's freshman class was Jewish. 30% of Harvard's freshman class was Jewish. And what percentage did Jews make up of the United States back in the 1920s? Well, I think it was less than 2%. I'm estimating that. It's less than, I think, 2% now. But so what did Harvard do? What happened at Harvard? What did everyone think about this? Well, the alumni and the administration at Harvard had a fit. This is completely documented in a number of books and articles and essays that the senior administration, the president of Harvard, was receiving letters complaining from alumni that they go to the Harvard football games, and literally, I'll never forget this, an influential alumni wrote to the president. He says, I look to my left, what do I see? Nothing but Jews. I look to my right, what do I see? Nothing but Jews. Something has got to change. And lo and behold, Harvard instituted what, for lack of a better term, the Harvard Plan. The Harvard Plan was instituted, and that meant that the test, the role of the test, the importance of the test, was greatly diminished, and some new factors were added to Harvard's admissions criteria. What were those factors? Something called leadership abilities. Leadership abilities and geographic locations. So that because most Jews lived in Philadelphia, New York, New Jersey, Baltimore, that Harvard was no longer going to just admit people who had great scores from those areas. They wanted, they wanted kids from other areas and other kids who had leadership abilities. Well, what happened the first year this new plan went into effect at Harvard? It's documented in our complaint, it's documented everywhere. Jewish students dropped from about 30, not quite 30% of the admissions grew to about 10% overnight. And it remained at about 10%, I think, through the 1970s or so, when it then started to go up slightly as a percentage. Harvard does not ask what your religion is. There's some anecdotal evidence that Jewish admissions have gone up a little bit since the 1970s. But that's what the original Harvard plan was all about, limiting Jews. Harvard had a Jewish problem. Today, Harvard has an Asian problem. Just, yes, sir.
First of all, I want to thank you for taking this initiative and making a complaint. And on behalf of Pakistani American, I've been, really appreciate all of you that come out and do support for this, because not only Asian is affecting in this